client's first-party bad faith claim against her uninsured motorist carrier, Travelers. And the trial court found that my client's civil remedy notice of insurer violation was defective, and that therefore the statutory condition precedent to bring the bad faith claim was not met. And the issue before this court on de novo review is simply whether the trial court's order of dismissal was proper. We ask the court to reverse for three independent reasons. The first is that this court should follow the 4th District's Julian decision and find that substantial compliance is the appropriate test when evaluating whether a filed civil remedy notice complies with the notice requirements in bad faith statute 624-155. The second argument is that even if the court finds that substantial compliance is not the appropriate test and that it is instead strict compliance, well, there's nothing defective about my client's civil remedy notice at all, so it did strictly comply. And then the third issue is that regardless whether or not we complied strictly or substantially, we would ask this court to follow the 4th District's Bay decision and find that Travelers waived its objections by not raising them, these alleged defects, in their response to the civil remedy notice. And if you agree with me on any one of these three issues, then you should reverse remand, reinstate my client's
recollection. What was the reason the trial judge gave for finding the notice, CRN notice defective?
The trial judge found that it was defective for two reasons. The only two things we're here to argue about. One is the policy language was, instead of there being relevant policy language provided in the civil remedy notice, counsel had instead written unavailable. And then the second reason is an omitted policy number. But that brings up
that was it.
That's it.
And that's something beyond your control.
Well, beyond my control, because I wasn't counsel.
I didn't know well, they didn't know the policy.
Well, they put the claim. They put the claim number. I mean,
they did put the claim.
I reviewed the civil remedy notice and Travelers' response. Travelers knew exactly what this claim was.
No question.
And responded. And it's got the claim number on here.
It does. If I could direct your honors to 4.
And
I'm sorry.
And no, that's all right. I'm sorry to interrupt, but I'm going to do it anyway. This is not a breach of contract. This is a civil remedy notice. This is a statutory claim for violation of the statute, not violation of the policy. So, there may not be any policy provision that's relevant. It's because what you're suing for is a violation of the statute. Is that not correct?
Correct. 100% correct, Your Honor.
And that's why it says if any. You've
That
got to say what part of the statute you violated.
That is certainly our
Which
reading.
may or may not relate to what's in the policy.
And we cite 3 federal district court cases: Wabshaw, a State of Arroyo, and Tropical Paradise
Well,
Resorts.
Travelers in their response to reaffirm what Judge Kelly just said. Travelers in their response said, we'll offer you $10,000, but we're going to deny we did anything that justifies punitive damages. So they knew it was a civil remedy notice. That's where the punitive damages came from, correct?
Not punitive, well, punitive in the sense that it's the damages recoverable under 627, subsection 10, which the Supreme Court has said is punitive in nature in the Friedman and the State Farm v. Lafayette cases. But not punitive damages in the technical sense. But you're 100% correct, Judge Monty.
Yes. Yeah, you led off with the Julian case, but in some ways the Julian case is helpful to you. But I mean, didn't in Julian the court there said that by citing almost all of the entire policy that was not substantial compliance, even if the court would have accepted the substantial compliance argument. So Julian is in some ways problematic for you.
Well, I think Julian's distinguishable. I mean, your Honor's correct that Julian is the case that adopted Pin-Pon, which is a federal district court. Judge Middlebrooks had said in the Pin-Pon decision that there's a 4-part substantial compliance test. And Julian cited that approvingly from the Pin-Pon decision. And it said in that case, in Julian, because it cited every single policy provision, and it cited, I think it was 36 different alleged statutory violations, that it was so ambiguous that the recipient, the insurance company, couldn't possibly figure out what they were actually complaining about. So that is a substantive defect, which is why it did not substantially comply. in the Julian case. But our
But here,
situation
you
is
say
totally different.
none or unavailable even. Is this, yeah. So in your case though, I mean, you're saying that it's the whole policy basically, or it's some of the policy or none of the policy. I mean, you don't give any.
Well, so
In other
The
words,
Julian
you've been
case-
better off saying not applicable as opposed to unavailable, because unavailable suggests that maybe there is.
I think unavailable, not applicable, that they're probably very similar. But the point is that the statute says it then. And if you look to the plain language of the statute, as the Wapshot, State of Arroyo, Tropical Paradise Resorts courts all did, they held that because in our case, unlike the Julian case, in our case, the only thing that was being alleged was a violation of 624, 155, 1B1, which is the failure to act in good faith. And we're not alleging any statutory violations. And as Wapshot, State of Arroyo, Tropical Paradise Resorts all found, you're not required to cite any policy language in those cases because you're not alleging a breach of the policy. And
Right.
and here, if you look at the policy, Travelers isn't even obligated to pay any uninsured motorist benefits under the policy until the legal liability of the underinsured tortfeasor has been determined. It's only because of the statute 624, 155, 1B1 that they have an obligation to try to resolve that case earlier and act in good faith and attempt to settle when there are all the circumstances it could and should have done so, had it been acted fairly and honestly towards its insured and with due regard for its insurer's interests. And that is precisely what we were alleging was violated here. So I don't want to spend too much time arguing about whether substantial compliance or strict compliance is the appropriate test, because under our view, it is an academic discussion for this particular case, but it certainly could be important for other cases. So let me just very briefly talk about the substantial compliance test. And in Judge Middlebrooks and the Pimpon decision, as we talked about, that was adopted by Julian, lays out this four-part test. And the four-part test says that the courts say that the failure to strictly comply with the civil remedy notice requirements, the notice requirements in the statute, will not eliminate the bad faith claim where four things are true. One, that the civil remedy notice contains a purely technical defect in the identifying information. Two, that the insured substantially complied with the notice requirements. Three, that the insurer received actual fair notice of the alleged violations. And four, that the insurer was not prejudiced by the technical defect. So that is precisely the situation we have here. The omission of the policy number in the policy language was an alleged technical defect, didn't mean anything. The civil remedy notice substantially complied, and you reviewed all the things that it had, and it's not like the Julian case, a case where Travelers didn't know what we were complaining about. They had actual fair notice of the alleged violations, and they weren't prejudiced. And the three federal cases that we cited, Apostolic Pentecostal Church, Fox, and La Brisa's Condo, all found that the failure to identify any specific policy language in those cases, which were first-party property cases, where the language actually was relevant, regardless, that was a technical defect that did not invalidate the civil remedy notice.
Tell me the difference between substantial compliance and strict compliance. It sounds like they're both the same. They sound like terms of art to me.
Well, the substantial compliance is just that four-part test.
Well, it includes substantial compliance, though. I mean, the strict compliance includes substantial compliance as one of the four elements.
I think if it's strict compliance, it's just, if there was any defect in the form at all, then it wouldn't strictly comply. And what the courts have said is that's not the standard that we're
So the
applying.
definition, you read was the definition of substantial compliance? I thought you read strict compliance.
I'm sorry, if I said that, I misspoke.
I'm
but-
not Mr. I'm old. Okay. Move on.
I'm talking about substantial compliance here.
Okay.
I also just want to point out in our notice of supplemental authority, we cited a federal district court decision from just 3 weeks ago in a case called Vintage Bay Condo that held that the listing of the wrong policy number and the wrong claim number were technical defects that did not invalidate the civil remedy notice because there the insurance company wasn't prejudiced. So as best I can tell, no court anywhere has ever invalidated a civil remedy notice other than the court below, where the only alleged defects was the missing policy number and the missing policy language. Now they argue about the Matherin case, which is a federal district court order, where the civil remedy notice was invalid because it had the wrong policy number. But there's a
There
distinction
was
there.
more than one policy.
Precisely, there were two. two State Farm policies with different limits and different cars, and they filed it, a Silver Remedy notice on policy A, and then tried to bring the bad faith claim as to policy B, State Farm never having had the opportunity to cure because there's never a Silver Remedy notice. Totally different situation in our case. There's only one policy. Everyone knows we're talking about the $100,000 policy limits.
Well, Counsel,
Chose not to.
well, I tend to
I'm sorry, Travis.
agree with Judge Middlebrook's analysis and pinpoint that there could be strict interpretation of a statute, while at the same time, when you're dealing with compliance, substantial compliance could be required in that umbrella of a strict interpretation of the statute itself. But here, wouldn't at least some core policy terms be significant? The covered losses, the policy limits, any other term, duties after loss? I mean, aren't any of those?
Respectfully, no, Your Honor, because we're only talking about their failure to act in good faith in attempting to settle the claim. And there is nothing in the policy that requires them to act in good faith in attempting to settle. This is an uninsured motorist claim. That is only in the statute, 624, 155, 1B1, which is different than the first party property cases, where they'll have an obligation to pay after the roof standards. Their actual legal obligation under just the language of the policy is after the determination of legal liability of the underinsured tortfeasor has been determined in a court. So it's just because of this statutory violation that they have the obligation, or the statutory obligation, I should say, they have the obligation to attempt to settle. And the three cases that we cited are with me on that exact point. Now, travelers, I just want to address their, if any, interpretation, because they say that it modifies the word violation. And with all due respect, that doesn't make any sense.
It doesn't.
I agree with Your Honor, because the whole
Can I-
reason to
I
file
hate
a
to
Silver Remedy
interrupt you,
notice.
But you're running low on time, and I have a question that I really need answered.
Absolutely.
I'm sorry, but can you address the waiver argument? Because what specifically, what would travelers, I mean, you're saying, oh, they waited 1,000 whatever days, so they waived it. What would they have had to have done to not waive it? What is your position? How do you not waive it?
They would just have to raise the technical defects, or maybe even a general statement that your Silver Remedy notice is defective. That would be sufficient. But here they didn't do anything to say that. They simply responded and counteroffered $10,000. So there was nothing about the policy language, policy number that mattered. I know I'm low on time. There's one point I need to make about the policy number. If the court was to apply strict compliance, I just want to make clear, the policy number likely wasn't even required in February of 2017. Now, we argued during the hearing that the policy number on the motion, the hearing on the motion to dismiss, the policy number wasn't required. We also argued that the trial court would commit reversible error by considering facts outside the four corners of the complaint. And yet the trial court did that when it determined that the policy number was required. And the reason this comes up is any practitioner who's filed a Silver Remedy notice in the past decade will tell you that on the website, there are certain boxes which are required and certain ones that are optional.
The Department of Insurance website.
I beg your
What are
pardon?
you talking about? The Department of Insurance website?
Department of Financial Services
Where you
website.
find, where you fill out the
Where you
form,
get
it
the
has the
form.
little red
Yes.
stars.
There are asterisks that will not even let you file it until all of the required fields are filled in. And by logic, if the policy number was a required field, they wouldn't have even been able to file it. And then I'll also point out that in the Wapshaw court, they noted that these fields and what is required has changed over time. And in Wapshaw, the Silver Remedy notice was filed 8 months after ours, and they listed in the opinion, there's multiple opinions, including the two that I just filed in the supplemental authority. It identifies 13 separate fields on the Department of Financial Services form, and policy number is not one of them.
Well, Counsel, don't you have a preservation problem with this issue in terms of whether or not this form required it at the time? I mean,
I respectfully, Your Honor, I disagree. I mean, we said during the hearing at page 478 of the record that the policy number was not required for all purposes under Florida law. And the argument that I'm making is that the policy number is not required. And also, on the preservation issue, I'll cite the court, your opinion in Ellison versus Willoughby, and I know this one well because I was on the receiving end of it, where the The appellant in that case wanted to argue that 768.041 entitled them to a set-off. But at the trial court, they only argued about 768.76. And this court found that, well, it's just the fact that we argued about the set-off and the fact that we were citing cases, even though you didn't cite the exact same statute that you're now arguing about on appeal, that's good enough, you preserve the issue. Well, if you're gonna apply that logic there, it should apply here. I mean, we've argued specifically, the court cannot go outside the four corners of the complaint to determine any factual issue, and that is precisely what the trial court did. And if you give us the opportunity to have this determined at summary judgment after we get to take the deposition of an IT person in the Department of Financial Services, I strongly suspect we will find that policy number was not even a required field back in February 2017.
All right, you're at 15 minutes.
Thank you, Your Honor.
Thank you.
May it please the court. My name is Matt Levitsky. I represent Travelers. This case begins and ends with statutory interpretation. Florida Statute 624-155, the bad faith statute, plainly and unambiguously required the appellant to provide both Travelers and the Department of Financial Services with a civil remedy notice that provided all of the information required by the statute. That included the policy language and the policy number. Appellant did not do that. The trial court corrected.
Wait, you said required by the statute? Doesn't the statute, just refresh my memory, doesn't the statute just say you fill it out the form provided by the department?
No, Your Honor. So Florida Statute 624-155-3A, I think it's important to look at the statute itself. First, it says a condition precedent, so make sure it's a condition precedent. And then subsection B says the notice shall, mandatory word, be on a form provided by the department. That's the first shall, it has to be on that form. And shall state with specificity the following information and such other information as the department may require. So it
You're
requires
relying on the and such other information.
for the policy number, but not
Right.
the policy language. Policy language is explicitly in the statute.
Well, if they're alleging a violation of the
No,
policy language.
respectfully, I disagree with that. I think
Well, we're gonna disagree on that, but for the benefit of the other two panel members, I'm gonna let you make your argument.
I appreciate that. So there's a few issues on this policy language. The first is that the appellant wrote unavailable, and Judge Valenti, I think you said, well, it's out of their control. I think you were saying maybe it's not available. It wasn't. They concede that on page 24 of their brief, that they had the policy, Travelers gave it to them at the time of the civil remedy notice a year before. On page 7 of the record is,
So it was not out of their control.
it was in their control. They had it and they attached it to the complaint in this lawsuit 1 year before they filed the civil remedy notice with a declaration from Travelers swearing to it. So first,
Why is what he said correct? You fill out the form, you do it online, check the boxes, and the computers will not accept it if it's not filled out correctly. Is that correct to say, to assume that or not?
I don't think it's correct to assume that. Respectfully though, or candidly, I don't know. I've never filled out a civil remedy notice. I represent insurance companies. But to Judge Stevenson's position, I don't think this was preserved. The first I heard of this argument was in the brief. But I don't know. I've never filled out a civil remedy notice. I want to go back to the policy language. So the appellant says that because there's the if any language, that modifies policy language and there might be no policy language relevant. And I think Judge Meriday had it right that if any modifies violation, not policy language. And the reason he's right is the nearest reasonable referent canon, which says that modifiers and qualifying phrases.
Okay, this is a statute that creates a cause of action for violation of the statute. And they alleged what statutory provision they believed was violated that they were going to sue on. This is not a breach of contract or breach of a policy provision. So doesn't it make more sense that maybe there's a policy provision, maybe not, and that's why you include if any?
Respectfully, no, I don't think so. If you look at the way the
So
statute
you're saying there has to be a policy provision cited?
in a coverage case, yeah, there's a.
No, this is a civil remedy for violation of the statute.
Yes,
This is a lawsuit for violating this statute. Are you saying they also have to allege, in addition to a violation of the statute, that you breached some policy provision?
no, they have to allege the policy language that's relevant to the violation.
Why?
Because first, because the legislature says so. But also because these policies, so if you look at 624-155, 1A, there's 1A.
Well, let me just back up.
Okay.
So you're saying they can sue, that in suing for a statutory violation, that if any applies, if we violated, if travelers violated any provision, so they can just sue for violation of policy
No,
language?
I think what the statute's saying is reference the specific policy language relevant to the violation, if any, if there is any violation.
Yeah, well, they can't sue if there's no violation of the statute.
Well, that's true.
That's the whole point of the statute.
Sure, and I think the legislature, the way they wrote the statute was not presuming there was a violation. But even if you look at this if any language, and you believe that perhaps it's optional in some instances, if you look at 1A, there's statutory violations for not renewing insurance because there's sickle cell traits, things that have nothing to do with the policy of
But
premiums.
let me just understand, they said unavailable.
Yes,
Had they said not applicable, would we even be here today? And they had the policy number up there.
if they said not applicable, it would be a tougher argument, I think, for me. If they were clearly stating there was no policy language relevant, but I think to Judge Stevenson's point, that's not what they said. They didn't say none. They came up with this position later after there was a motion to dismiss to say, well, maybe it's optional, maybe there was no language, but that's not what they said when they filed the civil remedy notice. Their position here is contrary to the position they took when filing the civil remedy notice. I also want to point out about the policy language, one other point. The statute goes on to say, if the person bringing the civil action is a third-party claimant, she or he shall not be required to reference the specific policy language if they've asked for the policy and not been provided it. So the inclusion of one thing suggests or implies the preclusion of another, the exclusion of another. The plaintiff in this case is not a third-party claimant. She's a first-party insured, and we know from page 7 of the record in the brief that she asked for the policy and we gave it to her. She had it a year before the CRM. So if it was optional in this type of case, that part of the statute really makes no sense in our position, or respectfully. The policy number also is required by the statute because it's on the form DFS 10-363. That's the form they filed. And if you look at Florida Administrative Code Rule 69J 123.002, that rule incorporates the form. So the form is
Well,
incorporated.
you got the claim number.
Yes, Your Honor.
Won't that tell you the policy number when you look up the claim?
Generally speaking, if you have a claim number, if you can search and find a policy number, that's correct.
Right, so you effectively have the policy number.
No, Your Honor, we have the claim number
No.
on the civil remedy notice. I agree that we could probably search and find the policy number on our own information, but there's a few problems with that analysis. The first is it's very similar to the analysis rejected by the 11th Circuit in Bollinger, where there was no civil remedy notice at all, but they told him numerous times, we're gonna sue you for bad faith. You did all these.
Well, but there's a statute that says you gotta do the notice.
That's right. And
So that's different, if you don't do the notice at all.
respectfully, the statute
Did
says.
you have any doubt? Any doubt at all what policy they were referring to?
I was not involved in the claim at the time.
Well, you guys, the travelers responded. You clearly had no question what policy this referred to.
We did respond to the civil remedy notice, that's true. The issue here is not, what I think the problem with this line of questioning, respectfully, Your Honor, is it gets to this idea of technical defects or
Right.
substantial compliance or prejudice. And in our position that analysis should not be applied. And so we do reject that analysis. I think,
Okay,
Okay.
I understand that.
okay, so Judge Stevenson, I think you mentioned, you thought that the Judge Middlebrooks' opinion might be persuasive. It's a rule of statutory construction that any statute in derogation to common law requires strict compliance with its provisions by one seeking to avail himself of the benefits. It's the Florida Supreme Court. We've cited a few cases that say that. This is clearly a statute in derogation of the common law. This Florida Supreme Court said that in Talbot. There are no shortage,
But it's also remedial, isn't it?
no. it's not
No, it
remedial.
wasn't to provide a cause of action where there had not been one.
So let me say a few things about the remedial statute argument. The first one is it's contrary to Talbot, which specifically says derogation of the common law must be strictly construed. And the 11th Circuit in Bollinger, relying on Talbot, specifically said that the argument that it's remedial in nature and should be liberally construed is clearly foreclosed by Talbot. Other cases say that too, including Pimpon. Pimpon rejected this argument. A remedial statute operates to further a remedy or confirm rights that already exist. That's not what this statute does. This statute created a right in a cause of action that the common law expressly rejected. Going back to Baxter, going to Talbot, Chalfant, the Florida Supreme Court and every appellate court has been very clear. There is no common law cause of action for bad faith because the relationship is debtor-creditor with no fiduciary. In 1982, the legislature created a statute to create a remedy that otherwise didn't exist. Therefore, it's clearly contrary and derogation of the common law. That requires strict compliance. And
Well,
this,
Counsel, even if we strictly construe the requirement of a CRN, couldn't that strict construction mean that it is a notice requirement? And I mean, couldn't that strict construction mean that you had to have notice? That the CRN had to be filed and it had to provide notice. That's strictly construing the statute. But then, as Judge Middlebrooks pointed out, couldn't you then look at what type of compliance with that strict construction is required? And there, even if you look at the narrative, it's a long narrative about what happened and as to why the suit was being filed. There's a narrative that can possibly save the lack of a policy number or policy provisions, could it not?
respectfully, no, Your Honor, the strict compliance requires strict compliance with the specific terms and requirements of the statute. The legislature determined what's important, and I think what's really problematic with some of the substantial compliance arguments and technical defects arguments is it requires this court to substitute its judgment for what's important for what the legislature put this in there, and the court should presume it was there for a reason. If you look at strict compliance, I would direct the court's attention to the Wooten case, which we filed as supplemental authority from this court just a few months ago, and that was a condition precedent. So you got to remember, this is a statutory condition precedent. And in that case, this court wrote that strict compliance was required and looked through the defects and said it didn't comply and therefore it was defective. So I understand, I think this is perhaps some of the view of Judge Middlebrooks in the pin pon of, well, perhaps I don't like the results, so I can kind of, we can use some equitable principles, but they don't really apply here. I mean, the court's role is to apply the statute as written. The statute's not ambiguous. My opponent said, if you're looking at strict compliance, this does not strictly comply. It does not provide that information. And they had the information available to them, and they didn't comply. I'll point the court's attention also to the PIP pre-suit demand requirements. Okay, those requirements have to be strictly construed. It's very similar to this. In a PIP pre-suit, you have to send a demand letter. There's lots of requirements. And the 4th District and the 3rd have said that the statute requires precision. That's the way that the statute reads. And they reject those. And to the point, Judge Kelly, about the waiver argument, there's nothing in the statute that requires an insurance company to respond to a civil remedy notice at all. And certainly nothing that requires them to identify the defects and tell the person threatening a lawsuit how to fix it. And if you look at the Thompson case that we filed as supplemental authority out of the 4th District, this was just this year, again, PIP pre-suit demand requirement. And in that case, the plaintiffs in the PIP pre-suit context argue much like here, well, when you got the demand, you didn't tell us what was wrong with it, therefore you waived it. And the 4th District said, there's nothing in the statute that requires them to respond and point out the defects, and rejected that argument. And so, and I think it's also kind of analogous to the proposal for settlement context. There's a line of cases, Judge Stevenson from your court in the 4th District, where the judges say, It might be a good idea if there was a requirement to say what's wrong with the proposal for settlement. But the courts, Judge Gerber in particular says, but it's not our role to tweak the statute, to modify it. It's our role to apply the statute as written, and that's what they do. And so that's what we're asking this court to do here. The statute is clear. It requires the policy language. It requires the policy number. They did not apply it. I also want to talk on the substantial compliance test and look at the Pin Pond decision, why I think the court respectfully should not be persuaded by it. Judge Middlebrooks focused almost entirely on QBE versus Chalfant, which is a case not dealing with a statutory condition precedent, nor a statute in derogation of the common law. That statute was about font size requirements. And so that's where I think it's kind of gone astray, and these federal courts following Pin Pond have gone astray. I don't agree that the Julian case applied a substantial compliance or adopted a substantial compliance test. I think they applied strict, but they analyzed it under the Pin Pond decision. But there's another case, Bay, which is cited by my appellant out of the 4th District, and they did apply and adopt a strict compliance test to 624-155. Now that was the waiver case, but if you look at the defect in that case, the defect was that they filed it against one USAA entity instead of the other. The 4th District said that did not strictly comply. We agree with the trial court that did not strictly comply. Judge Kelly, your point, I'm sure if they asked them, well, USAA knew between their subsidies who held the policy, perhaps, but the statute required.
No, I think it's a different company. It's a different entity. They might all be under a same umbrella, but no. So no, you got me wrong on that.
Okay, well, that's sort of how I see it, because the way insurance companies operate, there's a lot of paper companies, but they have the same employees. So a USAA and a USAA General have the same adjusters. It's just paper companies, so they would have that information. But I really do think that this case comes down to strict compliance. I also want to point out on the remedial nature of the statute in that question. The case that my opponent cited was Wagner versus Vaughn. Wagner and Vaughn versus Kennedy Law Group, that dealt with the wrongful death statute. That statute provides 768-17, quote, the act is remedial and shall be liberally construed. And if you look through statutes, that indication is in many statutory schemes. So the legislature knows how to tell courts that they consider statute remedial and should have a liberal construction. They didn't do that here. And so the court should just apply the plain language of the statute. It's unambiguous, and affirm the trial court. Unless the court has any other questions, so that's our position.
Okay.
Thank you, Your Honor.
Thank you.
Your Honor, there's 4 very brief points I want to make. First, as to whether or not this is a remedial statute or not, I would cite this court to its own opinion from Miguel Rolla versus Miguel, which is what we cited in our reply brief. To quote, remedial statute is one which confers a remedy, and a remedy is a means employed in enforcing a right or in redressing an injury. I don't know how you can say that the statute which creates the civil remedy is not remedial in nature. So clearly it is under that definition. Now, turning to the statutory interpretation. So if you look at 3B of the bad faith statute, it says, the notice shall be on a form provided by the department, shall state with specificity the following information, and it lists 1 through 5, and then it goes on to say, and such other information as the department may require. So of the 5, we're looking at number 4, reference to the specific policy language that is relevant to the violation, if any. We've talked at length about why there was no relevant policy language. So therefore,
But you said not available, like there was something in the policy that you could refer to, but you said it was not available, as opposed to this doesn't apply in a bad faith claim.
well, there's nothing in the record indicating what they were thinking when they wrote unavailable, but I think the question is just whether
You have the policy.
there's no question that we had filed a copy of the policy, but unavailable could also mean in the sense that there is no information that's relevant in the policy that is available to me to cite here. So I mean, I think that it's kind of a distinction without a difference to say
It's
not.
not maybe chicken and egg argument, but from the insurance company, I might make a different argument.
Okay, I'm gonna throw a wrench in here. So
Get ready.
in the I think in the last legislative session, they enacted 624-1551, which says that notwithstanding any provision of 624-155, A claimant must establish that the property insurer breached the insurance contract to prevail in a claim for extra contractual damages under 64.155(1)(b). Does that impact the fact that they're referencing specific policy language there?
Well, if
Breach the
anything,
policy.
it would go to support me in that, A, they're only there talking about property
Property
insurers.
insurance?
And my understanding of that statute is that it's making it difficult, if not impossible, to bring bad faith claims unless there is a breach of the contract in the first party property context, and that happens all the time. That there would be a breach of contract alleged, where here we're not alleging a breach of contract. The nature of the uninsured motorist claim is not really a breach of
It's a
contract.
generic duty not to settle a claim in good faith.
Well, that's the violation that we're alleging.
Well, Council, again, without the policy, you have no cause of action for bad faith.
Well, I suppose that would be true, that there had to be a contractual obligation or contractual relationship between the parties, but it says reference to the specific policy language that is relevant to the violation, if any, and here there was no specific policy language that was relevant to the violation. Now, on the policy number, that falls into the other information as the department may require, Cam. And there's no record evidence that the department required that information back then, and logic dictates that it wasn't required, and the Watchdog Court implies that it wasn't required. And that's why this was inappropriate to determine on a motion to dismiss. It should be handled on a motion for summary judgment so we can find out if the department did in fact require it. The form is in the record, but the form doesn't indicate which fields are required and which aren't. And we cited in our initial brief the website, and it says on the DFS website, Department of Financial Services, that there are some forms that are required and some that aren't. And I will tell you, as a practitioner who has filed civil remedy notice forms, they have changed over time. One final point about QBE. So QBE is in derogation of the common law. At common law, you can have any contractual relationship you want with your insurance company. There's no prohibition on the insurance company charging you a hurricane deductible. But the statute passed a protection for the homeowner saying, if you are going to have a hurricane deductible, then we have to have a notice that complies with these specific requirements. And the Supreme Court in QBE versus Chalfanti said, well, it's true that they didn't technically comply because the font was the wrong size, but we're going to apply substantial compliance as the test because there's no question that they had actual fair notice. And the Supreme Court upheld the charging of the hurricane deductible in that case, which is in derogation of the common law. And that is what Judge Middlebrooks was relying upon in part in the Pimpon decision, along with PRETA. And in this case, when PRETA was for the cancellation of the policy, another thing in derogation of the common law. That
Well, Council, one question as to your waiver argument. Isn't all of the cases that deal with waiver, dealing with such things as the wrong mailing address or misnaming the company by one letter, and so this is your waiver argument is a little different because you're saying that they waived a substantive argument about the CRM that they should have alerted you to.
Well, it's less substantive than it was in the Bay case, where they didn't actually even file a civil remedy notice to the right company. But the company went ahead and responded anyway. It was filed to USA Casualty instead of the United Services Automobile Association. And the reason that Bay comes out the way it is because it says the doctrine of waiver can encompass not only the intentional or voluntary relinquishment of no rights, but also conduct that warrants an inference of the relinquishment of those rights. So in the Bay case, what they're saying is by go ahead and responding without complaining that you filed it to the wrong entity, that was conduct which would indicate a relinquishment of the right to complain about it. And that is precisely what we have here. It's undisputed that Travelers was not prejudiced by any of this. I'm out of time.
Of your time, yes.
Thank you very much, Your Honor. So for these reasons, we ask that you reverse and remand and reinstate my client's advocate.
Thank you both. Appreciate it. Okay, our next case this morning